This is a seminar. Yes, I'm ready.
So I was going to introduce you, but I feel like you always take significantly more care in introducing yourself than I ever possibly could. Welcome everybody to the July installment of the Clark County Public Defender's Office Lunch CLE series. This month we are talking about issues regarding prosecutorial delay when the state chooses for some either strategic reason or otherwise to not promptly move forward into court with their charges, and what you can do when you see these kinds of problems. You all have the ability in this session to unmute yourself to pose questions. If you don't want to unmute yourself to pose a question, you could also post questions in the chat and I will get those to David at appropriate breaks. He does anticipate that there'll be some time at the conclusion of his prepared presentation today to be able to actually talk about some fact patterns. So I sent out an email this morning letting people know that if there were some questions they wanted to bring along those lines, that there will be time set aside for that. We'll try to get through as many of those as we can. And if at the end we haven't had an opportunity to cover your specific case-related question, you can send those questions to me and I will loop you back in on a group chat after the fact that we'll talk those things out over email with David. So with that, I'm going to turn things over to David and let him get rolling.
Thank you, Julia. I'm David Westbrook from the Clark County Public Defender's Office. I'm on the murder team, and in 2019, myself and my wife, Deborah Westbrook, won the Inzunza case in front of the Nevada Supreme Court. The Inzunza case is a very important case because, unlike a lot of legal theories or legal arguments, it can result in the full dismissal of your case. And generally speaking, that dismissal will not be fact-based. If you meet the criteria, it can be dismissed even if you have bad or unpleasant facts. So I'm going to go into that right now by sharing my presentation. Okay. Old Doggett, new tricks. Litigating prosecutorial delay with Inzunza, Barker, and Doggett. This is about speedy trial rights. The Sixth Amendment guarantees that in all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial. This is a fundamental constitutional right, and don't get confused. Judges often do get confused with this. When you're waiving the statutory right to a trial within 60 days, or for that matter, the statutory right to a preliminary hearing within 15 days, you're never waiving your Sixth Amendment speedy trial right. However, judges tend to have a shorthand where they ask you, does he want to waive speedy trial? And they don't specify whether you're talking about a federal right or you're talking about the statutory right. What we're focusing on here is the Sixth Amendment speedy trial right, not the statutory right. And waiving that statutory right does not impact your speedy trial rights. Even if a district attorney argues later that it does, they are wrong. When the right to a speedy trial has been violated, dismissal is the only possible remedy. In short, you can't cure the lack of a speedy trial by having a late trial. Late trials don't cure the destruction of a speedy trial right through the state's misconduct or through the state's, well, for lack of a better word, laziness. And I do mean laziness, as you'll see in a second. The key cases here are Barker versus Wingo, Doggett versus United States, and now, as of 2019, State versus Inzunza. Inzunza is the lead case in Nevada state law now, but it applies Doggett and a 4-factor test found in Barker. All right, teaching an old Doggett new tricks. This all starts with police investigation, and I'm going to take you through the facts of Inzunza in some detail because it'll give you an idea of when you have a Doggett issue and what type of case will give you a Doggett issue. November 3rd, 2014, North Las Vegas police began investigating sexual abuse allegations against Inzunza. At this point, they know exactly where he is. He's living in New Jersey. They have his home and business address. They have his cell phone number. He has an open Facebook profile, and his location settings are on. There are literal pinpoints when he goes to a national park and it auto checks him in, or when he goes to the Azteca restaurant in Trenton, New Jersey, and it checks him in. So they knew exactly where he was at all times. On December 3rd, 2014, a criminal complaint and an arrest warrant are filed on 15 felony counts, all serious felonies, sex assault, and related charges. Again, North Las Vegas knows exactly where he is, but they don't even try to contact him. They make no efforts whatsoever to contact him. They submit his name to NCIC and do literally nothing else. It takes 2 years and 2 months for him to eventually be arrested. As I recall, he was arrested on a traffic warrant or something similar to that. Now, this is the part where I was slow on the draw. When I got this case, I wasn't hip to Doggett. I knew about speedy trial rights, of course, but generally, when I thought about speedy trial rights, I'm thinking about post-arrest delay, the state asking for multiple continuances while my client sits in jail, the state not being ready for preliminary hearings or not being ready for trial and having to continue at the last minute, Hill and Bustos motions, missing discovery that causes delay. That was generally what I was thinking about. I really didn't have Doggett in my sights at that point. So Inzunza was indicted March 9th, 2017, and he was arraigned in district court on March 20th. On March 19th, 2018, about a year later, I finally filed a motion to dismiss based on Doggett versus United States. Now, in Doggett, the Supreme Court held that a delay of over 8 years violated speedy trial, where law enforcement's lack of effort in locating the defendant constituted negligence. In that case, similar to this case, they knew where he was. He was out of the country, but he was in some kind of federal custody. I believe it was in Panama. All they had to do, according to the Doggett court, was literally pick up a phone and call, and they would have been able to secure his presence, but they didn't do that. And they didn't do it for a long time. So the question is, what took me so long to file the motion? I explained a little bit, but really, it comes down to this. My bad. It's my bad. I had that nagging feeling that this doesn't seem fair, but similar motions filed in the past were filed without success. I talked to several people, extremely good attorneys in our office who had tried this before, and it just hadn't gone anywhere. At this point, prior to 2019, there were only about 6 published cases in Nevada that applied Doggett prior to Inzunza at all, and the focus of those had generally been on post-arrest delay, not pre-arrest delay. Or in another case, it was a combination of the two. No cases had ever presumed prejudice, and that is going to be a key thing that we'll discuss involving Inzunza and how it's applied. It's the presumption of prejudice. There was one case, and it was bad, which required a showing of particularized prejudice. In other words, there was some burden on the defense to show that because of the 2 or 3 year delay, a witness died, or evidence was destroyed in the normal course because of this delay. That was State versus Fain. What I tried to apply in my motion on Inzunza, and which was later affirmed by the Supreme Court, is that there is a 4-factor test to apply. Now, that 4-factor test is laid out in Barker versus Wingo. First, you start with the length of the delay. Now, there are 2 terms we're going to discuss here, and they sound identical, and sometimes they're treated identically, but they really don't mean the same thing. The first one is presumptive prejudice. After 1 year, there is presumptive prejudice in a case when there's been a 1 year delay. That's basically, I won't call it a bright line rule because courts like to shy away from calling anything a bright line rule, but it's about as close to that as you can get. There is presumptive prejudice after 1 year. That triggers the 4-factor test of Doggett. You look at the reason for the delay. Basically, what you're looking for is the question, is the state more at fault than the defendant? Now, it helps if the state is solely at fault. And that was the case in Inzunza. But under the law, the state doesn't have to be solely at fault, but it certainly has to be more at fault. And the defendant's actions will be considered when determining what to do. Next is the defendant's assertion of rights. Was there an actual invocation of a speedy trial right? In order to have a right to a speedy trial, you don't actually have to invoke it. However, to follow the four-factor test of Barker versus Wingo, you need an assertion of the right. It's written into it. So there's sort of a dichotomy there. But to be safe, always assert the right in the clearest terms possible. And the last is whether there was prejudice to the defendant. Now, Doggett says that affirmative proof of particularized prejudice is not essential. Now, that contradicts Fain, and as you'll find out later, because Doggett came after Fain, in Inzunza, the Supreme Court ended up invalidating Fain on those grounds and overruling it. Presumed prejudice requires a separate analysis. So as you can see in number 1, you've got a presumptive prejudice after 1 year. You would think that presumed prejudice would be exactly the same thing, but it is not the same thing. It's close. I think it's often confused, and I think you'll have judges treating it as the same, but in reality, it requires a little bit more of a showing. Presumed prejudice requires a separate analysis, but if prejudice is presumed, an affirmative showing is not required. So when you're looking to try to establish presumed prejudice, you're looking at several different things, which we'll get to a little bit later, but it involves essentially the culpability of the state in causing the delay and the length of the delay and several other factors. Generally speaking, if your delay is 5 years or greater, presumed prejudice is pretty much automatic. Now again, courts don't like bright line rules, but that's as close to a bright line rule as you can get. 5 years and up, it's basically automatic. But when you're within that 1 to 5 year range, as Inzunza was, he had a 26-month delay. At that point, you're going to have to do some analysis and some extra work. And it also helps in making your case, even though you're not necessarily required to actually try to show real prejudice. Okay, the hearing in State versus Inzunza. Filed my motion. Judge Ellsworth, noted defense-friendly pushover Judge Ellsworth, was the presiding judge, and she did the hearing. The hearing focused mainly on the pre-arrest delay. We covered both pre and post-arrest. There were tons of discovery issues that caused delay, etc. But the court focused in on that pre-arrest delay. And that was smart because it limited the issue for review later on, which I think really helped. And there's no debate whatsoever as to whose fault the pre-arrest delay was. It was somewhat debatable about the post-arrest delay. I don't think it was as debatable as the state thought, but there was zero debate about who was responsible for the pre-arrest delay. That made the issue very simple and made it easier for the Supreme Court to review. At 26 months, Barker Doggett was triggered. That's presumptive prejudice. The big question for Judge Ellsworth was, who was responsible for the delay? And that's where Detective Hoyt comes in. Detective Hoyt was the star and only witness, and unfortunately for the state, he was the star witness for the defense. They just didn't know it. So the detective received Facebook photos from the mother of the complaining witness showing Inzunza's home and his work vehicle, and the work vehicle had his phone number written on the side so you could see it in big letters. His Facebook page led to his work page and to websites, making it incredibly easy for them to contact him if they cared to try. So Judge Ellsworth actually questioned Detective Hoyt herself on a lot of these issues. She said, did you do any follow-up on those Facebook pictures, screenshots that you recall? Detective Hoyt said, I did not, no. I did local stuff, but it's Facebook, so you can't really trust the stuff on Facebook right now. Which I thought was interesting. This is an SVU detective who is actually, posed as a 13-year-old girl to entrap people online, and he's talking about how you can't really rely on information on Facebook. I thought that was irony. Did you call anybody? Asked Judge Ellsworth. Any friends or associates of the defendant who was the suspect in your case? No, ma'am. There was very limited information that I got from the mother and the victim, so that was his response. The detective submitted the case to NCIC, as I said earlier, and then he hoped that Inzunza would be located one day, and that was the extent of his investigation. Then he said this, and I bring this up specifically because the state actually argued that this was policy at North Las Vegas. He said, after we submit the case to the district attorney's office, it goes into a file cabinet. In there, we're hoping that the arrest warrant is issued. And then we're hoping that NCIC in another jurisdiction would hopefully pick him up, if not ours. So this is just in hopes that he is located. I wish there was more that we could do. It goes into a case file and out of sight, out of mind for us until we get subpoenaed. And he literally said the words out of sight, out of mind 3 separate times in reference to questions that Judge Ellsworth asked him. Fun fact, again, the state admitted this is North Las Vegas policy. And one of their arguments is that it can't be considered negligence or it can't be considered willful or unreasonable because it is a policy and he was following policy. The detective also testified that he was aware of Inzunza's speedy trial rights. In fact, he said that he agreed anyway, in response to Judge Ellsworth's questions, that they were trained on the Sixth Amendment and speedy trial. And he knew that not following up could jeopardize those rights and also the case itself. So he admitted to knowledge on behalf of himself and really on behalf of the entire department. He also admitted to calling other jurisdictions when investigating a high-profile case. So he could have made calls to New Jersey. He could have taken the extra steps necessary. But he said, this is I hate to say it, but a common sexual assault. We deal with this a lot, so much so to where it's common practice for us to just submit the case and hope that a warrant is issued. Yeah. Judge Ellsworth was not amused by that at all. I've gotten this look many times, and it was nice to see somebody else get that look. So Judge Ellsworth did a fantastic job making findings of facts and conclusions of law. She wrote 12 pages. She covered all the bases, and she essentially created something in order that was judgment-proof. There was no way it was going to be reversed because she was so conscientious in the way she wrote it. She granted the motion to dismiss. On factor 1, she found that the 26-month delay was presumptively prejudicial, so that means Barker-Doggett was triggered. On factor 2, she found out, she decided that the state wasn't just negligent, but also grossly negligent, and referred to the testimony of the detective as shocking testimony. And it really was shocking. Just the nonchalance with which he said, I did absolutely nothing, that's fine, we all do nothing. Factor 3, Inzunza did not waive his right to a speedy trial. Now, the state tried to argue, and they still argue this too, that unless you come to them and invoke speedy trial prior to your arrest, it doesn't count. I've heard them argue that. Or if you don't affirmatively invoke speedy trial at justice court, then you can't trigger Doggett and Inzunza and you're responsible for a delay. Okay. This is not necessarily true. Now, the court specifically found that a pre-arrest invocation of a speedy trial right, when the defendant's not even going to know that they have a warrant out there, is functionally impossible. But the key to invoking your rights is that you just do it as soon as you can. And so far, nobody has been held to have not invoked early enough. And even if they did invoke later as opposed to earlier, all that would do is it would go into the analysis about the post-arrest delay and who's at fault for it. And really, it shouldn't come out harshly against your client. But to be safe, as a matter of course, you should always invoke early and often. And whenever you change courts, you invoke again. Factor 4, the court presumed prejudice, and the state offered nothing to rebut the presumption of prejudice. And this became a big feature in the Inzunza Supreme Court case. The idea that the state actually has a burden here and not the defense when you have presumed prejudice. Okay, so in State versus Inzunza, the Supreme Court affirmed. Usually affirmances are a bad thing, but since we won down below, an affirmance was a good thing. I had to read it 2 or 3 times when we got it just to make sure. Justice Hardesty wrote the opinion. Justices Stiglitz and Silver concurred. Deborah Westbrook co-authored the brief. I take her all of the stuff that I lose down in trial court so she can fix it for me. The court relied on Barker and Doggett, so that specifically cemented Barker and Doggett as the test that we use here. Barker came first, and then Doggett clarified Barker, so they work in concert, although the 4-part test is originally in Barker. The 26 months was found presumptively prejudicial. Regarding the reason for delay, okay, you have, similar to spoliation of the evidence law, you have 3 different types of delay that can happen. Deliberate delay, which is willful and almost always, just results in a dismissal, again, nearly automatically. Then you have negligence in some form. And then below that, you would have valid reasons like a missing witness, which are not going to be held against the state, I would imagine, unless there are lots and lots and lots and lots of them over a long period of time. Asserting the speedy trial right pre-arrest, again, is not required or even possible in many cases. The Supreme Court also held that an affirmative showing of prejudice is not required in situations where prejudice is presumed. State versus Fain, that one bad case, was expressly overruled on this point. Now, the state still tries to trot out State versus Fain when opposing our motions. It's overruled expressly by Inzunza. Factors to consider when determining if prejudice will be presumed. Now remember, this is a different analysis than the first prong. This is the 4th prong of the Barker-Wingo test, and it's a little bit different. You look at the level of culpability. In this case, the inactions of the police were so egregious that it was easy, and the court found gross negligence. That finding was, entitled to deference, and it was really airtight because of how good the order was. The length of delay, both pre and post charge. If it is over 5 years, you're going to get that presumption automatically. If it's not, as this case was, between 12 months and 5 years, then this analysis becomes very important. Complexity of the crime. Is this some highly technical crime with lots and lots of evidence that the state is going to need extra time in order to figure out, or is it relatively simple? Is it a battery? Is there a reason why they took that long? The investigation by law enforcement. And as you can see from the testimony of Detective Hoyt, as a policy, at least in North Las Vegas, it's out of sight, out of mind. So there wasn't much investigation, which means that this prong is going to be difficult for them. And I hazard a guess that they haven't made a lot of changes as a result of Inzunza. And then whether the negligence was particularly egregious. In this case, it was. If shown, the state now has the burden to rebut the presumption of prejudice. It's not our burden to establish it if we can show that presumption. All right, practice tips. Always think Doggett. This is the mistake that I made. I was not on board with Doggett. I didn't have it at the front of my mind when reviewing case files for the first time. And if I had, it could have saved my client some time in custody. Maybe 9 months, maybe 10. Typical scenario. The suspect is out of custody. An arrest warrant is issued. The suspect has no idea that an arrest warrant was issued. The warrant just sits there for years until one day the suspect gets pulled over for speeding. The suspect is unpleasantly surprised to find that there is a warrant, they're arrested, and then you get appointed. If more than 1 year has passed from the date of the warrant and/or the charging document, sometimes you have one or the other, but you need one or the other, because that's what causes a Doggett scenario to happen, is an actual charging document or an arrest warrant being entered. Then you may have a Doggett issue. Now, some people ask in this regard, they took forever to charge the case. It was a burglary case, and they sat on it for 18 months before doing a charge. Then they finally, did the charging document and the arrest warrant at that point. That's going to go into a due process analysis, not a Sixth Amendment speedy trial analysis. And generally speaking, they will look at whether or not the case can be charged under the statute of limitations. And if it can, then they will assume that that's what the legislature intended, and so due process was satisfied. You need the charging document or the arrest warrant in order to trigger that speedy trial right. Preserve the issue. Affirmatively invoke your right to a speedy trial at the first opportunity. Literally say something like, my client is invoking the Sixth Amendment right to a speedy trial at Justice Court and again at District Court. Now, I was lucky. I did that, even though I wasn't supremely aware of Doggett analysis, just because I always do it. I just thought it was a good idea, and I've always done it since I started. I'm lucky that I did because there was no issue about whether I invoked speedy trial on my client's behalf, because I just did it as a matter of course. I lucked out. If you do this, then you won't have to luck out. You'll be doing it right. If you need to waive the statutory right to a 15-day prelim or a 60-day trial, be clear. Because again, the courts tend to just use speedy trial as a shorthand without actually referencing what they're talking about, federal or state. My client is waiving the statutory right to a trial within 60 days, but they are still invoking the Sixth Amendment right to a speedy trial. File your motion to dismiss. Apply the 4-part Doggett-Barker test and cite to Inzunza. If you lose, you can follow up with a writ of mandamus. When you do that, you're arguing that there is no plain, speedy, and adequate remedy at trial. Now, there is a recent unpublished order where a writ was denied, and they said you can just, take this up with us if you lose a trial on appeal. That was an unpublished order. I don't particularly like where that's going because in my way of thinking, a writ of mandamus is designed to avoid a situation where your client is sitting around in custody waiting for a trial that should never go in the first place because his speedy trial rights have been violated. Under Doggett, the only remedy for a speedy trial violation is dismissal. So having a trial, or in this case, a late trial, doesn't remedy anything. So therefore, every writ should at least be heard by the Supreme Court, because you cannot cure a speedy trial violation with a trial. Even if you win the trial, your client has suffered. They've had the prejudice of deprivation of liberty, which is one of the classic forms of prejudice. Also, the reasoning behind showings of prejudice not necessarily being the purview of the defendant is because it's very difficult. And the Doggett Court and now the Supreme Court in Inzunza recognize this. It's very difficult to establish true prejudice when you have one of these old cases. It's very difficult to determine and to express what damage was done to your case and to your analysis because the time and the situation naturally makes it difficult. What witnesses would have been available? Have people's memories suffered because of the long delay? Has evidence disappeared? Sometimes you never find out whether that happened or not because it has disappeared and it's gone, and so it's going to be out of your knowledge. If your client's been in custody, you can always show deprivation of liberty as a fundamental form of prejudice. But whenever you file these and you get to that fourth prong, do your best to show actual prejudice because it makes the question a lot easier to answer in the form of your motion. If you want sample motions, we've got them. That's my email address. You can also just email Julia and she'll forward on your requests to me or to Deborah, who will probably be answering some of them if I can't. That's usually who I ask when I don't know things. And before we finish this prepared part of the presentation, I want to talk about some office superstars. Since Inzunza came out, the case has been used by numerous people in the Clark County Public Defender's Office, and I believe the Special Public Defender's Office as well, in order to get great results. And again, it's only been out for 2.5 or 3 years. Rebecca Sachs has gotten dismissals twice. Allison Coombs has gotten at least one dismissal. Scott Ramsey, Ben Little, Jake Gullo, and Carly Kearney got a dismissal. They appealed. Deborah Westbrook wrote the brief and they won. You also get sweet deals when you file these motions. On serious felony cases, we've had gross misdemeanors with probation. We've had misdemeanors with credit for time served, just being tossed up because the state knows that they are in a real bind post-Inzunza. So filing this motion when it's at all non-frivolous, when you have any basis to file it, can help you deal a case, even if you don't go to the stage of getting it dismissed. Rebecca Sachs, 2 different times, got great deals. Michael Van Loven, I believe his case was an attempted murder that he got knocked down to a gross in credit or a gross in probation. Maybe it was even a misdemeanor. Deanna Keene, 3 different times has gotten great deals because of these motions, and Ben Little has gotten at least one himself, maybe more. I'm sure there's other people who have emailed me their stories that I forgot and I left out of here, but I apologize for that. But suffice it to say, this is a great motion to file. Be aware of it when you first open up your file on a case, and try to assess whether or not you have a Doggett issue, because it is a great way to either move cases or to get them dismissed. And with that, I will open the floor to questions and factual scenarios if you want to run them by.
Would like to run one by you.
Hit me.
Just got appointed on a new case. Fortunately, my team member wrote Doggett with multiple exclamation points after it. So
That's my kind of note.
I can't take any credit for spotting the issue. But basically, my client and his now ex-wife, then wife, were charged with multiple counts of burglary and theft for trying to cash bad money orders at the Money Tree. And essentially, so there was an agreement with the ex-wife's and her private lawyer to just kind of take care of it informally. And then the police report says that she stopped making payments. And so they requested an arrest warrant. So my client, 11 years later, just went to apply for a security job at a casino, and they told him about a warrant. And so he went and put it on calendar to quash the warrant himself. And then the proceedings started against him. So that was like 10, 11 years ago that this started. And the detective knew where he lived. The detective had interviewed him as part of this. So I don't see anything. The report just says, I can't find, either of these defendants.
But he did nothing at all to actually affect. I mean, as long as your person is living openly, if they're hiding because they know there's a warrant out for them, then you're not going to succeed. But it sounds like he wasn't living in hiding. He was living his life openly. The detective actually had information they didn't bother to follow up on. Right. What department is this, Metro or?
This is in Henderson.
Henderson, okay. I have no reason to think that either Henderson or Metro does anything particularly differently from North Las Vegas as far as following up. They got a lot of cases. This case is not the most serious case in the world to begin with. It really sounds like a civil matter to me, just from your factual description. But 11 years, that means that on the 4th prong, you get a presumption of prejudice. They have to rebut the presumption, period, end of story. 11 years is 3 years longer than Doggett itself. This should be dismissed, and you might want to file it in Justice Court if you haven't proceeded past Justice Court yet.
Okay.
Now, you will get flack from some Justice Courts because they believe they have limited jurisdiction and they can't entertain constitutional motions or motions to dismiss. Some Justice Courts hold tight to that. I don't agree with it. I don't think it's true. I think their jurisdiction is generally limited in very specific ways, and if it's not a specific limitation or a specific case that says that they don't have jurisdiction over A, B, or C, then under Goldsmith versus Sheriff, they have that jurisdiction because the rules for district court in general are the same as they are for Justice Court and vice versa, unless specifically enumerated otherwise. So you have a motion to dismiss on a speedy trial violation. The Sixth Amendment Confrontation Clause doesn't apply to Justice Court, but the Sixth Amendment still does, which means that you have a speedy trial right. And every minute that that case spends in Justice Court is another minute that your client's speedy trial rights have been violated. And after 11 years, I mean, that violation is done. So this case should be dismissed. And really just bringing it up might get it dismissed because I don't think the DA, if I was the DA, I wouldn't want to respond to that.
Okay. And I just sent you an email for a sample briefing. Thanks, David.
Yep, no problem. It's a good example. That's a winner.
So David, I've got a question in a much, more mundane scenario, but it's kind of COVID related. I have a couple of cases in a municipal court up here in the north where the court's just forgotten about it. Everybody's working from home. including court staff, which is one of the reasons why that's awful. But I've got at least 2 clients, I think 3 right now, where literally a file just got lost at the court. In one case, it's been over a year since the last hearing. We filed every, we have records of all our communications, trying to seek a new court date, and then I quit doing it at some point because it's not my job.
Right.
Have you ever encountered that or dealt with that, where it's already been in court, and the state and the court itself just has refused to move forward with it?
I haven't dealt with that yet, but we're all going to be dealing with that in some form or another. I do have a case, a murder case, that keeps getting put off because of COVID. And I have filed speedy trial motions in that case, which Judge Levitt denied. I hope you weren't drinking anything when I said that, because you probably spit it across your desk to hear that Judge Levitt denied a defense motion.
Well, I'm in the North, so I don't know Judge Levitt from anybody, but
Do you know Darth Vader? Like that, but with sun-damaged hair. Okay, so
fair.
it's
Well,
a situation that we're going to have to
Go
deal with.
ahead. I'm sorry.
I mean, it's not the state necessarily causing that delay, right? It sounds like the court doesn't have space and they don't want to deal with it, and the state just never gets ready because they know it's not going. Is that what's
What is
happening?
the state? They have the responsibility. My argument is that will be ultimately that my intention is to probably wait another year or so and then file a motion for just refusal to prosecute, because at some point the state has a responsibility to keep track of their own cases, and they're the ones that presumably want to prosecute my client.
At every point, they have that responsibility. I mean, that's what Doggett is all about. And really, the state in this scenario, in my reading of it, is prosecutors, police, any actors or agents of those, under like Mazan and Kyle's. But my first question is, has your client actually asserted the right to a speedy trial?
No,
Because
in fact, again, these are relatively minor Muni-Court traffic accident cases. We continued a couple times by stipulation to try to get some insurance information at some point. So it's not really a Doggett Barker issue, because I've litigated that quite a bit. And I have a second question about a more serious case.
Sure.
Just get your thoughts on it. I was just curious about that, where a case has just literally fallen between the cracks and it got lost at the DA's office and at the court, and nobody cares. And I have a lot of cases recently where, because DA's offices are also closed or people are working from home, things just get lost in the bureaucracy. My intention is to be even more aggressive about challenging some of that, because I think it's egregious, and it is somebody's fault that stuff gets forgotten about. So I was just curious if you'd had any kind of experience with that.
I haven't with that, but I think that the flaw is going to be, they're going to say that you're part of the system that is causing the delay because you haven't asked for a speedy trial. Now, you have a right to a speedy trial whether you ask for one or not, but as far as trying to dismiss something because of delay, I think that you have an obligation to actually require or ask for a speedy trial, and then if you don't get it, you can get a dismissal. What you're talking about, it really does sound like it's more just failure to prosecute.
Right.
If they really don't care that much, I mean, why don't you call them up and tell them to dismiss this stuff? Hey, listen, let's wipe up our books. Like you haven't thought of that, I'm sure.
Right. No, I'm going to let that lie until a little bit longer, and they don't have as good. So the other thing though is that I'm curious if your office. So I did one of only 3 jury trials that was done in 2020 post COVID, in Washoe County. It was 3 Category A felonies, child sex trafficking. He did invoke, and in January, and we did this. It was a little outside the 60, but we made that distinction. So I was glad to hear that, because we did that.
Okay. So he invoked his right to a trial within 60 days, as well as.
No. He waived it for a week so that we could keep it in the same department.
That's still an indication, I think.
Right.
I mean, he only waived it. If you put a limitation on the waiver and that's accepted by all parties, then 60 days is still in play.
Right. So, and I just saw your wife's comment there that it's pandemic, it's not anybody's fault. I profoundly disagree. It's absolutely the government's fault. They chose to do those things. And so whether or not that was justified is the question, not whether or not it's the state's fault. And so it's that case. He was eventually went to trial in September. It was originally set in March, and then it was set in May, and then it got continued in September. it's kind of a cumulative error issue, but I'm arguing that, all of these things have impacted the speedy trial right profoundly, and not just for him, although this is an early opportunity for the Supreme Court to weigh in on it, but for everybody else. I got another murder case right now where the guy's been in custody literally over 3 years. I just got it. There was a kind of late conflict, and he had previously waived, but at some point, delay, ongoing delay, and the possibility of an executive order essentially suspending habeas corpus and delaying it further. I guess I'm a little surprised I haven't seen more litigation on that. I'm curious what your thoughts are.
I've been litigating the same issue. And here's what I've sort of bent over backwards to do. I actually completely agree with Deborah. I think that the court is going to do what they can in regards to that second factor to say that the pandemic delays are not going to be imputed against the state. And even though, it's the courts making the decisions, we're just going to have to live with those delays. Because if they don't, it's going to be a can of worms that they do not want to open. So I think that they're going to try hard to justify that, and they've got a decent grounds to justify it. So what you need to do, I think, and this is what I'm doing, and we'll see if it works. Hopefully I'll never find out if it works, because I'm just going to win my trial. I'll blow my grade issues and win my trial. But if I don't, the record that I tried to set up was to show in very specific terms that pandemic or no pandemic, the state was never really ready to proceed. They were essentially relying on this pandemic to get free continuances and not doing their job. There was so much discovery that they haven't turned over even now with the trial again a month away because it got moved once again over my objection. There is discovery that was lost, destroyed because they said they had it, and then they said they were going to get it, and then they didn't do it until it was already gone. So if you can show that the state has actually caused a delay that would have existed whether the pandemic existed or not, then I think you're going to be in a better position on that second prong than you would be just saying, pandemic schmandemic, the Constitution doesn't care. The Constitution requires you to get a speedy trial, which I think is a fair argument. Absolutely. I don't recall reading anything that says you get a Sixth Amendment speedy trial if it's convenient. But I think a better argument is, listen, the state was going to cause a delay anyway. They don't get a free ride here, not doing their jobs just because there was a pandemic.
Well, and on that, I don't know if you're aware, there's a case out of the Ninth Circuit called Olson that just came out that specifically addressed that and actually created a test for the federal court where there was a judge there in the Ninth Circuit who was in the district court in California, and federal court was just dismissing him and said there's no pandemic exception. So Olson's that case. I forget the site. You can email me if you want, but sure. And that's on my appeal as well. I guess I was curious if that was coming through the pike through some of the public defender's offices. So
I think it will be eventually, but really, at this point, up until about 3 weeks ago, we were still getting pandemic delays. They've stopped that down here, and they're saying be ready to go forward. And they've opened up the courtrooms. So I think those things will happen once trials get rolling, but I don't think they're going to happen as pretrial writs. I think they're going to happen on appeal, which means we're probably still 8 months away from anything happening. But if anyone has one that's going up, call me. I'd love to talk to you about it. Anyone else with anything exciting? We have 6 minutes left, but I think we can round up. Isn't that how private works? I think we can round up to the hour.
We can certainly. Oh, we got one. Sorry.
All right.
Hey, Brian. Nice to see David. Nice to see you. Listen, I've got a child sex assault victim under the age of 16 against Lisa Lusage that was supposed to start on Monday. It did not go forward because Lisa tested positive for COVID. And that was terrible for my case, oddly. The reason being is that the defendant was arrested in January of last year, has insisted at every stage that the record reflect that he was invoking his right to speedy trial, including justice court. And then the pandemic hit him by the time I was appointed as alternate counsel. Judge Delaney, sua sponte, continued his trial maybe 4 times until June or July of this year. Now, because of the nature of the case, and I'm trying to figure out what to eliminate, there were valuable child witnesses. All of the relevant witnesses in this case are juveniles, and all of them were housed at Child Haven. And so initially, the state identified the children on the witness list as care of the Clark County District Attorney's Office. I filed a motion to strike saying that that was not compliant. Lisa knew and I knew that there was direct visual recording evidence and contradictory testimony that said that the original complainant had lied to the police. The question was, how much had she lied about it with regard to the sex assaults? In any case, I believe that Lisa Lusage wanted to prevent me from being able to speak to any of the witnesses that would help destroy her case. So she starts off by identifying it as CO, the district attorney's office. I filed a motion to strike in September. That was granted by Delaney. By the way, for everyone listening, Delaney is pretty good on striking deficient witness lists. If they don't comply with statute, you can get relief in DC 25. However, immediately afterward, Lisa amended the witness list to change the address to Child Haven, who also has a policy of not confirming or denying the presence of any juveniles in their custody, and of course not letting defense counsel or the investigator speak with them. At which point, enter me, I now have to accept some fault. The pandemic hit me like it hit everybody else, and I stopped working on that case for quite some time. When I came back up for air, knowing that this man had invoked his right to speedy trial, I tried to make sure that it would be ready to go in June. Delaney was unable to accommodate. She moved it into a July setting. And lo and behold, Lisa still hasn't provided me any of the following. Like, for example, I don't have a transcript of my defendant's statement to police.
Sure.
I don't
well, who's your second chair?
It's just me on this.
No, who's her second chair?
She hadn't announced. I believe that if there was one now, it would be Rob Stevens, but I'll get to that in just a second. And so at any rate, there are quite a few pieces of discovery that I do not have, up to and including the surveillance video that directly contradicted the juvenile's claim that she had been forcibly kidnapped and brought inside of an apartment where she alleged to have been sexually assaulted. Additionally, there was some discovery that came back that said that the semen recovered from the juvenile's vagina did not belong to the defendant. And so that required me to file a motion to admit, et cetera, on sex issues and, and break rape shield. My point is this. My intention was to file a second motion to strike, which I did with an OST, along with a motion to dismiss, et cetera. Those things are still coming, essentially saying to Delaney that the state did not provide any of the essential discovery, despite multiple requests that I could track all the way back to the preliminary hearing. Unfortunately for me, Lisa Lusage says that she tests positive for COVID. She calls in sick Wednesday of last week, and Judge Delaney sua sponte says, well, we are now going to continue the trial. Despite central trial having said, this is through Judge Jones, the state needs to have an attorney there in order to do this trial and respond to Mr. MacArthur's motions.
Right, and it's different for the state than it is for us because, you know, for them, they always say, well, who's the next one up? You know, it's not like they need to do vertical representation. And the state doesn't have a Sixth Amendment right to counsel in the same way that a defendant does as far as their choice of counsel. But look, I think that you could file a speedy trial motion on this. This is really focusing on post-arrest delay, obviously, and not pre-arrest delay. But your whole anchor on this is that the state's not ready. They've never been ready. If Lisa Lusage, had a false positive and was back in court tomorrow, they still wouldn't be ready. And COVID is not an excuse not to do your job. They have other people to work on their cases when they are gone. I guess also you could say if she wasn't vaccinated, it's negligence, but that might be going a little bit too far.
I like going too far.
Yeah, it sounds to me like, they're not ready regardless of whether or not there's COVID. That has nothing to do with it. So you're in kind of a similar situation as to me, because they haven't given you discovery that is required for you to go to trial. They like to announce ready, but to me, when you announce ready, what that means is, what the state is telling the court is, I have complied with my legal obligations. That includes the production of discovery. And if you're still getting stuff like this, and some of it maybe being bombshell exculpatory evidence, then they are not ready. They have never been ready, and they have not complied. So file your motion, see what happens. Maybe
All right,
someone smart over there will deal the case.
I appreciate your input. My fear is that now that Delaney has already ordered the trial continued into my trial in September, the state will now use this interim to provide me with all of the things that they refused to provide me before.
Well, you might want to do a motion to reconsider the continuance and make a due process argument, because if it was done sua sponte, then you never got a chance to chime in and make your record.
Understood. Thank you much.
I don't like the sua sponte nature of it, especially when we're trapped between two courts, where you have one court, the central trial readiness calendar, saying one thing, and then you have another court saying another thing. I mean, that's an awkward situation from a due process standpoint as well. In the same way that it was awkward when they were using your invocation of the right to a trial within 60 days to determine whether you even have a chance at going to trial. So you would have people who have been in jail for 60 days who would get to be on the list, and people who have been in for 3 years who may have waived 60 days, but did so without knowing that in waiving 60 days, they wouldn't get a speedy trial under federal law, just suffering for longer amounts of time. I think that's a huge issue that might end up being litigated. I mean, I've got a case with that issue as well. So, it's a weird place for due process to be. My fear is that courts are going to try to just protect the prosecution on these so they don't have to wholesale kick cases left and right because so many people have been affected in the same way. But I think it's worth filing.
All right, that's my perception as well. I'll let you know how it goes.
Thanks.
Thank you.
So we are at an hour. I'm fine with more questions if you want. Anyone who wants to can call me. My number here is 702-455-1762. That's 702-455-1762. Operators are standing by. And you can also send me an email. You're muted, Julia.
Muted this. Thank you for everyone that attended. In August, off the top of my head, I believe it's on the 24th, but I will be sending an email out shortly. We will have our next lunch series, and it will relate to all issues regarding parole. What to do when you have a client on a parole hold, how to handle a parole hearing, good negotiations versus bad negotiations, and the various outcomes that they have pre-designated for case resolutions when you go to the parole board, things of that nature. That will be hosted by Lynn Avance here at the Public Defender's Office, as well as one of our new attorneys who was working with him doing exclusively parole hearings for about a year, Edith Palafox. So you guys will all be receiving more info soon. And if you have any follow-up questions regarding today, feel free to reach out to David or to me. And the PowerPoint will be sent out to all who attended once I format it to be sent out. So that'll probably be later today, if not tomorrow morning. Thanks, everyone. See you in August.